Workers' compensation benefits protect employees when they're injured on the job by paying the cost of medical care and lost wages. Agencies are required by state law to provide these benefits. Workers' compensation is a form of insurance providing wage replacement and medical benefits to employees injured in the course of their employment in exchange for mandatory relinquishment of the employee's right to sue their employer for the tort of negligence. Many issues with regard to workers' compensation benefits, such as the amount of payments for certain types of injuries, are dictated by state law and generally handled by an agency's workers' compensation provider. Other aspects of workers' compensation benefits are up to the employer, such as how sick leave benefits, health insurance, and wages are handled when employees are out on workers' compensation leave. Workers' compensation laws do not address these leave requirements. These laws address benefits, including medical expenses and wage loss that employees are entitled to for work-related injuries. The agency's workers' compensation administrator, or the agency itself if self-insured, will make decisions regarding the appropriate length of benefits. How long the employer continues the employment of an individual on workers' compensation leave is a decision of that agency. And that leads us to termination decisions. Although the agency cannot terminate an employee simply because they filed a workers' compensation claim, the employer can terminate an employee because he or she is no longer able to physically perform the essential functions of the job. The employer should decide such situations on a case-by-case basis, taking into account its obligation under the law, like personnel policies regulating FMLA or ADA compliance. Workers' compensation payments for lost time due to work-related injuries are paid at 2/3 the employee's normal weekly wage. Agencies may supplement workers' compensation benefits either through the use of paid leave or injury on duty pay. Many union contracts and personnel policies provide for this type of supplement. However, employers must ensure that workers' compensation payments are treated as non-taxable income and supplemental wages are treated as taxable income. There are also differences in how these two types of income are treated for the purposes of PERA contributions. Workers' compensation law does not require agencies to continue their contributions toward health insurance, such as health and dental and so on, while the employee is out on workers' compensation leave. However, if the workers' compensation injury qualifies under the Family Medical Leave Act, the agency must continue its contribution towards group health benefits during the period of time covered by FMLA, up to 12 weeks. In addition, if the employer's policy is to continue insurance contributions for employees out on other types of unpaid leave, then it should also do so for employees out on workers' compensation leave. Otherwise, the agency could open to claims of discrimination or retaliation under workers' compensation law. Some employers establish a time limit on unpaid leave. As an example, they offer 12 weeks in order to cover an FMLA requirement, after which it will send a COBRA notice to employees and discontinue the agency's contribution to health and other types of insurance. If the employee can return to work with restrictions, consider whether restricted duty, often called light duty work, is an option. Leave benefits, workers' compensation laws, or union contract requirements may result in the agency paying the employee's wages whether or not the employee is at work. Some employers prefer to bring the employee back as soon as possible. It may be necessary, however, to defend such a decision if such work is granted to some employees but not others. If offered, the agency should develop a written policy on light duty that includes, at a minimum, when light duty will be provided, including specific criteria, the data required to be provided prior to granting light duty assignments, including verification the employee will be able to return to duty full-time in the future, and who has the authority to approve that light duty, as well as a periodic review of light duty assignments, such as every 30 days.